The National Broadcasting Company and the American Association of Colleges for Teacher Education, in cooperation with the American Political Science Association and the National Council for the Social Studies, present Continental Classroom, a course in the structure and functions of American government, conducted by Dr. Peter H. Odegard, Professor of Political Science at the University of California at Berkeley. Professor Odegard.
As administrative head of the government, the President, in addition to his power to appoint and to remove officials, which we discussed the other day, must also be able to issue orders, directives, rules, and regulations to control their official behavior. And these orders must have the force of law if they are to be effective. He must also stand in some kind of a protective relationship to them when, in the performance of their duties, they may become defendants in litigation brought against them for any number of reasons. Now, as we've seen before, with a very few exceptions, the courts have sustained the power of the President when he acts under the broad authority of an act of Congress to issue rules and regulations having the force of law. There have been some exceptions to this where the court has held that Congress could not delegate legislative power to the President. But by and large, the court has sustained the power of the President to issue rules and regulations under the authority of an act of Congress, and these rules and regulations or orders have the force of law. But what about orders that are given to executive officers and agents without formal authority of any law of Congress, other than the constitutional grant of power to the President? Now, the classic leading case in which this question was resolved was the case of In re Nagel, a case decided by the Supreme Court in 1890. The facts of the case can be stated, I think, rather shortly. In those days, it was the custom for members of the Supreme Court to ride circuit, that is to say, to sit on circuit courts in various parts of the country. And Justice Field, a member of the Supreme Court of the United States, while sitting in circuit in San Francisco, had ruled against a certain litigant, a man named Terry. Terry, in an outburst of anger in the courtroom, had made an assault on a federal marshal in the courtroom, whereupon Justice Field, sitting on the bench, had ordered him to be imprisoned for a period of 6 months for contempt of court. On his release, Terry was, of course, very angry at the justice and made open threats against his life. It became so serious that the matter was laid before the Attorney General of the United States in Washington, and the Attorney General, acting on the authority of the President of the United States, assigned a deputy marshal, a man named Nagel, to protect Field from violence. To carry out his threat, when he got out, Terry tried, as I say, threatened to attack Justice Field, and then one day Justice Field appeared in a restaurant in a railroad station. And Terry showed up at the same time. Nagel was with the justice. Mr. Terry was seen to get up and advance toward the justice, and Nagel said he had a knife in his hand. So Nagel, responding to his duty to protect the justice from violence, shot and killed Mr. Terry in the railroad station. Nagel was promptly arrested by the local authorities and held on a charge of murder. He appealed to a federal court for a writ of habeas corpus and was released by the federal court on the ground that he could not be held in custody for an act done in pursuance of a law of the United States. Now, Nagel acted not under any law enacted by Congress, but only under an executive order issued by the authority of the President. The question was this a law of the United States. It was argued, and I quote, that neither the Attorney General nor the President, acting through the Attorney General, could by law or was empowered by law to send a deputy marshal for any such purpose. If there was a law authorizing it, what was it? Now the Supreme Court of the United States, upheld the federal court, the lower court, and upheld the discharge of Mr. Nagel by saying, in taking the life of Mr. Terry, Mr. Nagel was acting under the authority of a law of the United States, that is to say, an executive order of the President, and is not liable to answer in the courts of California. The court went on to say that when by the Constitution the President is invested with the executive power of the nation, and when the Constitution enjoins upon him that he shall take care that the laws be faithfully executed, the Constitution confers upon him all the powers that are reasonably incident to the exercise of this executive function and necessary to the enforcement of the laws. And the power so granted in the Constitution to the President, Congress has, nor has never claimed to have, the right to abrogate or to repeal. That is, the court said, the executive power conferred on the President by Section 1 of Article 2, when this was taken in conjunction with his obligation to see that the laws are faithfully executed, this does confer upon the President a power above and beyond the powers that are enumerated in Sections 2 and 3 of Article 2, and also over and above any power that may be conferred upon him by an act of Congress. The court said that Congress can no more impair or abrogate this inherent executive power than the President can impair or abrogate the legislative power of Congress. Now this principle, that an executive order of the President of the United States to one of his subordinates is the law of the land and can not only be enforced in the courts, but can serve to protect their agents from liability when carrying out a lawful duty, puts a pretty firm foundation under the power of the President to see that the laws shall be faithfully executed, and gives to him the kind of authority that he needs as the nation's chief executive and administrative officer. I ought to point out that in the Nagel case there was a vigorous dissent, written by Chief Justice Fuller, in which he said, we recognize that the powers of government may be found not only in the express authorities conferred by the Constitution, but also in those that are necessarily and properly implied. But he says, Section 8 of Article 1 says that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the laws of the United States. Congress, not the President. And consequently, said Justice Fuller, the protection needed for Justice Field must proceed not from the President, but from Congress. And in the absence of congressional authorization, the President had no power to issue an order that would have the force of law, because this would have been, in the language of Chief Justice Fuller, to invade the domain expressly committed by the Constitution to the Congress. Well, now, these doubts raised in the dissenting opinion, as a matter of fact, the majority opinion was established and is still the prevailing law. But the doubts raised in the dissenting opinion were raised again very dramatically in 1952, when President Truman, acting under a law of, not under a law of Congress, but under the executive power of the President, and under his power as Commander-in-Chief, ordered his Secretary of Commerce to take possession of the steel industry to prevent a stoppage of steel production as a result of a steelworkers' strike. Now, the background for this, I think, can be sketched briefly and is important. You may remember that in June 1950, North Korean troops from communist North Korea crossed the 38th parallel and invaded the Republic of South Korea. The Security Council of the United Nations ordered the withdrawal of the North Korean troops and at the same time called upon the United Nations members, and I quote, to furnish such assistance to the Republic of South Korea as may be necessary to repel the armed attack. And on the same day that the United Nations issued this call, June 27th, President Truman, as Commander-in-Chief of the Armed Forces, ordered United States Air and Naval Forces into Korea. The United Nations immediately followed this by voting for a unified United Nations command, and on July 7th, General Douglas MacArthur was designated as the United Nations commander as well as the American commander. And on July 20th, President Truman called for $10 billion of added appropriations for arms and munitions, and we found ourselves in a shooting war, not by act of Congress, but by act of the President of the United States. The Army moved fast. It moved across the 38th parallel into North Korea and was moving in October toward the Manchurian border, far to the north, when Communist Chinese sent an army across the Chinese border, across the Yellow River, and attacked the United Nations forces, compelling them to retreat. And they did retreat and fell back toward the 38th parallel in a disastrous and bitter struggle, very costly in terms of both life and materiel. And on April 11th, after Douglas MacArthur, the general in command, had threatened an all-out attack on Communist China, President Truman removed him from command and replaced him with General Matthew Ridgway. Whatever you may think of the president's wisdom in removing Douglas MacArthur, and there was great indignation expressed in the country at the time, one must remember that the president's power as commander-in-chief to do this is without question. Well, now, while this was going on, the United Steelworkers contract expired on December 31st, 1951. And on December 18th, the union gave notice of its intention to strike unless a new contract was signed by December 31st. Every effort was made to come to some kind of an agreement. The Federal Mediation and Conciliation Service was called in without effect. The President then referred the dispute to the Federal Wage Stabilization Board, and the board was unable to get an agreement between the union and the employers. And on April 4th, 1952, the union gave notice of a strike that was to begin at noon 5 days later on April 9th. In the meantime, the fighting was going on in Korea, and the President was convinced that the strike would jeopardize national defense. And so on April 9th, a few hours before the strike was to begin, the President issued an executive order to his Secretary of Commerce to take possession of the steel mills and to keep them running. And the Secretary Sawyer, did so on the President's authority, called on the steel company's executives to continue to manage the steel mills under the authority of the United States. The day after the President issued this order, April 10th, he appeared before Congress and reported what he had done to Congress. Congress did not respond. 10 days later, he reported again to Congress. Again, Congress did not respond. It took no action. It didn't say the President couldn't do this. It didn't say he could do this. In the meantime, the steel companies complied with the President's order, but did so under protest, and immediately went into a federal court and asked for an injunction to set aside the president's order as illegal and to restore the mills to their control. The lower court granted the injunction, and the government appealed immediately to the Supreme Court of the United States in one of the most important cases that has been decided on this issue, the case of Youngstown Sheet and Tube against Sawyer. As you see here on this card, I think you can get the title of the case better if we show you how it looks. The Youngstown Sheet and Tube Company against Sawyer. The case was decided in 1952 in June. The court handed down a very complex and in many ways confusing opinion. Justice Black wrote the opinion for the majority of the court, and there were no less than 3 concurring opinions, concurring with Justice Black. There were also 3 judges in dissent in this case. The question that was before the court, as Justice Black saw it, writing for the majority, was this: was the president acting within his constitutional power when he issued an order directing the Secretary of Commerce to take possession of and operate most of the nation's steel mills? Now, the mill owners, in answer to this question, said the president did not have the authority to do this, that this was an act of lawmaking, and this was a function which the Constitution confided to the Congress and not to the president, that therefore the president's order was unconstitutional and illegal. The government, on the other hand, said the president's order was necessary in order to avert a national catastrophe, and that in meeting, and I quote, in meeting this grave emergency, the president was acting within the aggregate of his constitutional powers as chief executive and as commander-in-chief of the armed forces. That is to say, what the government was arguing here was that the president had an inherent power that he derived from the Constitution itself, a kind of prerogative to look out for the public good and the national defense without the authority of any specific law. Now, this argument has been made many times. It was made by Thomas Jefferson. You may remember that some time ago I quoted Jefferson to the following effect, as he wrote in 1810. He said, "A strict observance of the written laws is doubtless one of the high duties of a good president, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when it's in danger, these are a higher obligation. And to lose our country," said Jefferson, "by a scrupulous adherence to written law would be to lose the law itself." You may remember that Andrew Jackson threatened to send 40,000 soldiers into South Carolina when South Carolina threatened nullification and refusal to obey the laws. You may remember that Abraham Lincoln, at the time of the crisis over Fort Sumter, not only called for militia, called for volunteers, spent federal funds, blockaded southern ports, and did all this without any act of Congress. And Lincoln explained all this by saying, was it possible, he said, to lose the nation and yet preserve the Constitution? I felt that measures which were otherwise unconstitutional might become lawful by becoming indispensable to the preservation of the Constitution through the preservation of the nation. And of course, finally, this was put very bluntly by Theodore Roosevelt when he said, "My belief as president was that it was not only the president's right, but his duty to do anything that the needs of the nation demanded unless such action was forbidden by the Constitution or by the laws." Now, it's perfectly obvious that the president's order to seize the steel mills was not forbidden by the Constitution or by the laws. The question was, had it been authorized? And the court's opinion, the court says the president's power to do this must have come from one of two sources. It must either have come from an act of Congress, which Congress had the constitutional authority to enact, or secondly, it must come from the Constitution itself. The court says, as to the first, there is no statute, and I quote the court, there is no statute that authorizes the president to take possession of property as he did here, nor is there any act of Congress from which such a power can fairly be implied. The court went on to say that in the debate in Congress over the Taft-Hartley Act, it had actually been proposed that the president be given this power, but Congress had rejected the proposal, thus indicating, according to the court, that Congress did not want the president to have it. Well then, if he didn't have statutory power, did the president have power to issue his order under the grant of power to him in the Constitution itself? Now the court says there is certainly no express power granted in Article 2 to the president to seize private property. You can't find it in the Constitution. Can the power therefore be implied from Section 1, where it says the executive power shall be vested in a president? Or can it be implied from the constitutional provision that he shall take care that the laws be faithfully executed? Or can it be implied from the provision that says he shall be commander-in-chief of the armed forces? Now, the answer which the court gave to this question was that the power of Congress to authorize this order is beyond question. If Congress had given the president authority, it would have been legal. But the Constitution, said the court, says that all legislative power shall be vested in Congress. The Constitution does not give the president lawmaking power. It gives this power to Congress and not the president, and the legislative power is not under military supervision or control. And then the court goes on to examine whether or not the president could have issued this order as commander-in-chief. It says the order cannot be sustained as an exercise of the president's military power as commander-in-chief, because the court said we cannot, with faithfulness to our constitutional system, hold that the commander-in-chief of the armed forces has the power as such to take possession of private property in order to keep labor disputes from stopping production, even presumably in a case of de facto war. If Congress wants the president to have that power, Congress must say so. Without act of Congress, the president does not have the power. That was the opinion of the court. Now, some of the concurring opinions are interesting. They're mainly rhetorical, but the rhetoric is rather interesting in many respects. Mr. Frankfurter, for example, says that the founders of this nation were not imbued with the modern cynicism that the only thing history teaches is that it teaches nothing. They felt that you could learn from history how dictatorships grow step by step. Now, he says, I'm not saying that Harry Truman is a dictator, but dictatorship comes slowly from the generative force of unchecked disregard of restrictions that fence in political power. And Justice Douglas said the Congress, as well as the president, is the trustee of the national welfare. To be sure, the president can act more quickly than the Congress. All executive power, he says, from the reign of ancient kings to the rule of modern dictators, has the outward appearance of efficiency. But we cannot decide this case by determining which branch of government is most efficient. The answer must depend on the allocation of power under the Constitution. And he then quotes Justice Brandeis, the late Justice Brandeis, as saying, the doctrine of separation of powers was adopted not to promote efficiency, but to preclude the exercise of arbitrary power. Justice Jackson undertook, in his concurring opinion, a more systematic review of the President's powers as Chief Executive. And he said there were three different kinds of situations that the President might confront. One, where the President had a specific grant of power from an act of Congress that Congress was constitutionally authorized to enact. In this case, he says the President's powers are at their greatest because his power includes all of his own constitutional powers plus all of those that Congress can delegate. And had this been the case here, the President's order would most certainly have been sustained. There's a second type of case where Congress does not act for some reason, and the President has to act in an area in which the distribution of powers between Congress and the President are not clear. In this case, circumstances will decide the issue. And then the third case, he said, where the President's power is at its very lowest, is where the President not only does not have an act of Congress to rely on, but in which Congress has said he should not act, as in this case. And hence he held the President's order could not be justified either as executive or as commander-in-chief. The court said, as a matter of fact, that as commander-in-chief he has very broad powers, particularly when he is facing an outer enemy. But when this is turned inward, we cannot grant him such indulgence. Now, the steel seizure case here raises in dramatic and specific form the scope of power not only under the executive power, but the powers of the President as commander-in-chief, to which we will turn at another time.
This has been a pre-recorded NBC educational production.